Hi, in this immigration law update video, I want to give a quick summary of the plans and arrangements for hearings before the Upper Tribunal Immigration and Asylum Chamber during the COVID-19 pandemic. On the 23rd of March 2020, the President of the Upper Tribunal Immigration and Asylum Chamber, Mr. Justice Lane, issued a Presidential Guidance Note number 1 of 2020, which is entitled Arrangements During the COVID-19 Pandemic. And this guidance is issued in response to the Pilot Practice Direction, which was issued by the Senior President of Tribunals. Now, this does say that there will need to be amendments as things go on, and I'm recording this brief video on the 31st of March 2020. So I do encourage you to do two things. Have a read of the Presidential Guidance Note in its entirety, and I'll put the link below the video, and also check if there's been any updates, because I think as things carry on, things will have to be amended on the fly. So what's happened? Well, on the 19th and 20th of March 2020, the Upper Tribunal informed the parties that hearings beginning on the 23rd of March 2020 and following had been postponed. So what's the plan going forward? Well, drawing on paragraph 4 of the practice direction from the Senior President of Tribunals, the plan is that where hearings can be dealt with or where decisions can be made without a hearing, that should usually be the way forward. And of course, there's power for that in Rule 34 of the Upper Tribunal Procedure Rules, having regard to the views of the parties. So now, what I'm not going to do in this video is give commentary, and practitioners will be aware as they listen that certain issues will arise, and you'll have to give a think to what representations are made to secure the interest of your client in representing them to the best of your ability before the Upper Tribunal. But the plan is that where there hasn't been an error of law decision yet, the Upper Tribunal judge will consider the case on the papers and give a provisional view in writing to the parties on whether the FTT decision involved the making of an error on a point of law, and if so, whether the FTT decision should be set aside. And directions will be given to the parties then to make further submissions on the error of law issue and on the set aside issue. And also the respondent, whoever the respondent is in the appeal before the Upper Tribunal, will also be able to make a reply. The Upper Tribunal judge will then proceed to make a final decision on the error of law issue. If the decision is set aside, the Upper Tribunal will then have to decide whether to remit the matter back to the first tier or to keep it in the Upper Tribunal. And if it's kept in the Upper Tribunal, whether there needs to be a hearing and whether that hearing involves the giving of further evidence. The default position, if there's going to be a hearing, is that it will be done remotely. And obviously there's an ability to do that by telephone and through video links such as Skype for Business is referred to at paragraph 20 of the practice note. And it's anticipated that as much as possible, these will still be done as public hearings. Have a look at paragraph 21. Documents need to still be filed in by post, but where there's going to be an electronic hearing, they also need to be filed and served electronically before a hearing. Bundles should be confined to what is essential and don't include authorities, but just provide a list of citations. The attachment limit is 15 megabytes per email. In terms of the remote hearing itself, guidance is given of how you log on and how the judge will log on at paragraphs 27 and 28. If there's a need for oral evidence, that's dealt with at paragraph 29 and 30, and whether this can be done through a remote hearing or if the case would actually need to be adjourned for a proper normal oral hearing in due course. And paragraph 31 reminds us that these arrangements may need modification in due course. At paragraph 32, it confirms that the big word have indicated that interpreters will be available for remote hearings. There's guidance on judicial review proceedings before the Upper Tribunal from paragraph 33 to 36. Urgent applications need to be lodged electronically. Normal applications can still be lodged in person, by hand, or by post. And as a final matter, the President says this at paragraph 37, and I'll read it to you to close. It needs to be appreciated that unfolding events during the pandemic may affect the extent to which the UTIAC can operate by reference to this guidance. In any event, the need to adopt new ways of working may well lead to challenges on the ground, which will need to be approached sympathetically by parties and the UTIAC alike. So I hope that's helpful. Have a read of the guidance in full, but the takeaway summary is the new normal will be there will be a provisional view on the error of law decision on the papers. Then you'll be able to make representations. And if there then needs to be a rehearing on the case and the decision of the FTT is set aside, the presumption will that be a remote hearing, and then there'll be a decision made then whether evidence is heard and what form that'll take. Thank you.